I was 39 years old, sitting in a lawyer's office in downtown Toledo with a coffee stain on my scrub top, when a man in a gray suit slid a piece of paper across the table and told me I was worth $2,400,000. I laughed. He didn't. That's when I knew something was very, very wrong. Good day, listeners. It's Diane here. Before I continue, like and subscribe and leave your comment. My name is Diane Marsh, and at the time all this started, I was 47 years old, living in a rented two-bedroom on Elmhurst Avenue in West Toledo, Ohio, working as a dental hygienist at a practice called Mommy Family Dental. I'd been there 11 years. I cleaned teeth, made small talk about people's vacations while my hands were in their mouths, and drove home every night to make dinner for my daughter Casey, who was 17 and had been diagnosed with type 1 diabetes when she was 9. I want you to understand who I was before any of this happened, because it matters. I was not a woman who chased money. I clipped coupons. I drove a 2014 Honda CR-V with 138,000 miles on it and a check engine light I'd learned to ignore. I paid $340 a month for Casey's insulin, even with insurance, because our plan had a high deductible, and some months I split a pill of my own blood pressure medication in half to make the bottle last longer. I was by any measure financially unremarkable, underestimated maybe. My ex-mother-in-law once told me, not unkindly, that I made do well for someone who didn't plan ahead. I let that comment go. I let a lot of comments go. I'd been divorced from my ex-husband, Todd Marsh, for 6 years by then. We split when Casey was 11, not over anything dramatic, just two people who'd stopped fitting together, who argued more about the thermostat than anything that mattered. Todd worked in fleet logistics for a trucking company in Perrysburg. He wasn't a bad man. He paid child support on time, mostly. He showed up for Casey's diabetes appointments when he could. I want to be fair to him in this story, because what happened later wasn't really about Todd at all. It was about his father, Walter Marsh, my former father-in-law. I need to tell you about Walter because he is the hinge this whole story swings on. Walter was 78 when I first met him. 22 years ago at Todd's and my engagement dinner at a steakhouse off Route 20. He was a quiet man, thin as a fence post, who'd grown up on a family farm out near Wauseon, Ohio, in Fulton County, about 40 minutes southwest of Toledo. He didn't talk about the farm much. When he did, it was in short sentences, like he was rationing the words. Sold it in '81, he told me once when I asked. Wasn't worth keeping. I remember thinking that was a strange thing to say with the particular flatness in his voice, like a door closing on a room he didn't want me to look into. That's the first thing I want you to remember. File that away. The second thing, Walter and Todd had a falling out around 2015 over something neither of them would explain to me. Todd stopped visiting his father for almost 8 months. When I asked Todd why, he just shook his head and said, "It's old business. Leave it." I never pushed. That's the second thing to remember. The third thing, Walter used to send Casey birthday cards with $20 bills folded inside every single year, without fail, even after Todd and I divorced. Even after the falling out with Todd healed and rebroke twice more over the years, he never once sent a card to Todd's older brother's kids, his other grandchildren. Just Casey. I noticed it. I never asked him why. Walter Marsh died in March of 2023 at 84 in a nursing facility in Sylvania, Ohio, of congestive heart failure. Todd went to the funeral. I did not. We'd been divorced 6 years by then. It didn't feel like my place. Casey went, in a black dress I'd bought her for her cousin's graduation. That was the last I thought about Walter Marsh for 14 months, until the letter came. It was a Tuesday in May, the kind of gray Ohio spring day where the sky can't decide if it wants to rain. I'd just gotten home from a 9-hour shift at Mommy Family Dental. I remember because my hands still smelled like fluoride gel, and there was a cream-colored envelope in my mailbox, heavier stock than a bill, with a return address I didn't recognize: Ochoa and Reyes, Attorneys at Law, 4112 Superior Street, Suite 6, Toledo, 043604. I almost didn't open it that night. I almost put it on the kitchen counter under the stack of Casey's insurance paperwork and forgot about it until the weekend. I'm glad I didn't. Inside was a single typed letter, dated May 14th, requesting that I contact the office at my earliest convenience regarding a matter pertaining to the estate of Walter T. Marsh, not Todd, me. I stood in my kitchen holding that letter for a long time, Casey's insulin pen still sitting on the counter from her dinner dose, and I thought, this has to be a mistake. Walter's estate would go through Todd or through Todd's brother, Craig, not through his ex-daughter-in-law. I called the number the next morning before my shift. A receptionist put me through to an attorney named Renata Ochoa, and she asked if I could come in that Thursday at 10 a.m. I told her I had patients booked, she said, and I remember this exactly because of how she said it. Flat, no drama, like she was reading a weather report. Ms. Marsh, I'd move the patients, so I moved the patients. Thursday morning, I sat across a scarred oak conference table from Renata Ochoa, a woman maybe 55 with silver-streaked hair pulled back tight and a coffee cup the size of a soup bowl sitting at her elbow. She had a manila folder in front of her, thick, rubber-banded twice. "Miss Marsh," she said, "do you know a business entity called Fulton Ridge Holdings, LLC?" "No," I said, "never heard of it. Did you know that your former father-in-law, Walter Marsh, retained mineral rights on a parcel of land he sold in Fulton County in 1981? No, I said again, and I felt my stomach do something strange, a slow drop, like the first hill of a roller coaster. He told me he sold the farm outright. He said it wasn't worth keeping. Renata slid a document across the table, a mineral rights deed dated September 1981, Walter T. Marsh's signature at the bottom in blue ink gone slightly brown with age. He sold the surface land, she said. He kept the subsurface rights. Oil and gas exploration started up in that part of Fulton County again in 2009, horizontal drilling. Fulton Ridge Holdings has been leasing those rights and paying royalties into a trust account since 2011. Okay, I said slowly. So Todd inherits that, or his brother. Renata looked at me for a long moment, and I remember she picked up her coffee, took a sip, and set it back down before she answered, like she wanted the silence to land first. Walter Marsh executed a trust amendment in October of 2019, she said. The Mineral Rights Royalty Trust, everything Fulton Ridge Holdings has paid and will continue to pay, was assigned in full not to his sons but to his granddaughter, Casey Marsh, with you named as trustee until she turns 25. How much? I said. My voice came out smaller than I wanted it to. As of the most recent quarterly disbursement, Renata said, the trust account holds $2,411,000, and it is still generating royalty income, approximately $18,000 a month. I laughed. I actually laughed, a short, ugly, disbelieving bark of a sound, because it was the only thing my body knew how to do with information that size. Renata did not laugh. She just watched me, steady, like she'd seen this reaction 100 times before and was waiting for it to pass so we could get to work. "There's no mistake?" I asked, when I could talk again. "None," she said. "But Ms. Marsh, I want to be straight with you before you get too far into feeling good about this. Walter Marsh skipped both of his sons in that trust amendment. Todd and Craig get nothing from the mineral rights. That kind of decision doesn't happen in a family without a reason, and in my experience, reasons like that don't stay quiet for long. I didn't say anything. I just sat there with the deed in my hands, the paper cool and dry under my fingers, thinking about $20 bills folded into birthday cards and a sentence Walter Marsh once said to me at a steakhouse off Route 20 wasn't worth keeping. I drove home that afternoon and sat in my car in the driveway for 11 minutes before I went inside. I didn't tell Casey, I didn't tell Todd. I just sat there alone with the engine ticking as it cooled, trying to figure out what I was actually feeling, because it wasn't only joy. Underneath the joy, quiet and cold, was something that felt a lot more like fear. I didn't sleep that night. I lay in bed doing math in my head that had nothing to do with money, the kind of math you do when you're trying to add up a person's whole life to see if it adds up to a lie. Here's what I had. As I lay there in the dark, a trust worth $2.4 million, sitting 18 years in a name I'd never heard until that morning, built on land my former father-in-law told me to my face wasn't worth keeping. Here's what I didn't have: any idea why he'd cut out both of his sons, or why he'd chosen me, really, since I'd be the one controlling it for the next 8 years instead of leaving it split evenly like a normal estate. I thought about the falling out between Todd and his father in 2015. 8 months of silence, never explained. I thought about how Walter used to send Casey those birthday cards faithfully every single year, even through 2 divorces worth of family chaos, like he was keeping a promise to someone. I thought about the way he said sold it in 81 with that particular flatness, like there was a second sentence behind it he decided not to say. I was afraid of a few very specific things, and I made myself name them, lying there in the dark, because naming things is the only way I know how to make them smaller. I was afraid Todd's brother, Craig, would find out and come after it. Craig had never liked me much, even during the marriage, and he'd always run a little hot about money, ever since he'd lost his HVAC business to bankruptcy in 2018. I was afraid this would blow up my relationship with Todd, who was, whatever else he was, still Casey's father and someone I had to coordinate with for the next year of her senior year and beyond. And underneath both of those, I was afraid of something with no name yet, a feeling that this money hadn't been given to us. It had been left to us, the way you leave a note before you disappear, and notes like that usually have something in them you don't want to hear. I got up around 2 a.m. and made a cup of tea I didn't drink. Just held, sitting at my kitchen table in the dark with the deed Renata had given me spread out under the light over the stove. I looked at Walter's signature again. That faded blue ink from 1981 wasn't worth keeping. He'd lied to me at that engagement dinner 22 years ago, small and casual. The kind of lie you tell so many times it stops feeling like one, and then at the end of his life he'd quietly undone it. Not by telling the truth, but by writing a legal document that would only make sense once someone went looking. I decided, sitting there at 2 a.m., that I was going to go looking. Slowly, carefully. I wasn't going to touch a dollar of that money, and I wasn't going to tell Todd or Craig anything until I understood exactly what I was standing on top of. I called Renata Ochoa back on Monday and asked her, point blank, to help me find out why Walter Marsh had done what he did. She leaned back in her chair, laced her fingers over that soup bowl coffee mug, and said, "Ms. Marsh, I have to tell you something about myself, so you know what you're hiring. I don't do gentle. If we go digging and we find something ugly, I'm going to hand it to you exactly as ugly as it is. I've had clients ask me to soften things. I don't soften things, I just get them right." I told her that was exactly what I wanted. Over the next 6 weeks, Renata and I built what she called the paper trail, and I built what I privately called to myself the truth about Walter. We started with Fulton Ridge Holdings LLC itself. Renata pulled the Ohio Secretary of State business filings and found the LLC had been registered in 2009 by a registered agent service, which told us nothing on its face, until Renata cross-referenced the original organizer's signature against county probate records and found the name Diane Whitcomb Reyes, a paralegal who, it turned out, had also notarized Walter's 2019 trust amendment. That felt like a thread. It turned out to be a dead end. Ms. Reyes had simply been the notary of record for half the small estate work in Fulton County for 20 years. But it taught me something important. This was going to be slow, real investigation, Renata told me over her third coffee of one particular Thursday. Isn't like the movies, it's mostly dead ends. You just can't stop pulling threads because the first 6 didn't lead anywhere. The real break came in July. From something almost embarrassingly ordinary, newspaper archives. Renata had a research assistant, a quiet 26-year-old named Priya Nair, who spent 4 days combing the digitized archive of the Fulton County Expositor on microfilm scans going back to the 1970s. Priya found a marriage announcement from June 1968. Walter T. Marsh, 23, of Wauseon, Ohio, married to a woman named Loretta Speck, 19, also of Wauseon, not Todd's mother. Todd's mother, Carol Marsh, was the woman Walter had been married to for 46 years, the woman who'd raised Todd and Craig, who died herself back in 2011. Nobody in the family had ever mentioned a first wife. I remember sitting in Renata's office when she told me this, feeling the floor tilt slightly under the chair legs.
There's more.
Renata said, and slid another document across, a birth certificate also pulled from Fulton County Vital Records, dated April 1969, a baby girl, Marianne Speck Marsh, mother Loretta Speck Marsh, father Walter T. Marsh. He had a daughter, I said before Carol, before Todd and Craig. It gets more complicated, Renata said. Loretta Marsh filed for divorce in Fulton County in 1971. The divorce decree, I had to subpoena the sealed portion of the file, which took me 3 weeks, and a judge's signature includes a custody arrangement. Loretta got sole custody. Walter's parental rights weren't terminated, but the decree notes he agreed to, quote, relinquish claim to marital farm property in exchange for uncontested custody terms. I sat back in my chair. The farm, I said, the one he sold in '81, the one he kept the mineral rights on. The same farm, Renata said, which means when Walter told you it wasn't worth keeping, he might have meant something a lot more literal than you thought. He might have meant he'd already given half of it away once, to a daughter he never told your ex-husband existed, and he spent the rest of his life trying to figure out how to make that right without anyone finding out he'd had a whole other family before Carol. That was the document-based gotcha moment, and it changed everything about how I understood the trust amendment. Walter hadn't skipped Todd and Craig out of spite. He'd been trying at 80 years old, quietly and without confession, to route money toward the branch of his family that history had already shorted, and Casey, his granddaughter through Todd, had simply been the safest, quietest vessel he could find to eventually make it right, because by 2019, when he wrote that amendment, Marianne Speck Marsh, his first daughter, was already dead. She died in 2016 in Toledo of ovarian cancer at age 47. She'd had one child of her own. That child's name, we found through the same Fulton County Vital Records search, was Renee Speck, age 31, living in Bowling Green, Ohio, 45 minutes south of Toledo, and, as it turned out, completely unaware that Walter Marsh was her biological grandfather. I want to pause here and tell you what was happening in my own life while all of this was unfolding, because it wasn't happening in a vacuum. That same summer, Casey's diabetes management got harder. She went through a stretch in June where her blood sugar swings were bad enough that her endocrinologist wanted to switch her to a continuous glucose monitor and a different insulin pump, a combination our insurance only partially covered, and the out-of-pocket cost was going to run us close to $4,000 for the year, even with the discount program. I was also 2 performance reviews away from a possible promotion to office manager at Mommy Family Dental, which would have meant better insurance and $6,000 more a year, a promotion I was terrified to jeopardize by seeming distracted, so I told no one at work anything about the trust. I was documenting evidence about a dead man's secret first family during my lunch breaks in a supply closet on my phone, so nobody would see the emails from Renata's office pop up on the break room computer. By late July, word got out, not through me, through Todd. He'd run into Craig at a 4th of July cookout, and Craig apparently had heard from someone at the Fulton County Recorder's Office, small towns talk, and Renata's subpoena for the sealed divorce file had left a paper footprint that some lawyer from Toledo was digging into old Marsh family land records. Craig called Todd. Todd called me. Diane, Todd said, over the phone, his voice tight in a way I hadn't heard from him in years. What is going on? Craig says you're going through Dad's old records. Is this about money? I told him the truth, carefully, the way Renata and I had rehearsed, that his father had left a trust to Casey involving old mineral rights, that I was trustee until she turned 25, and that I was doing my due diligence to understand it properly before disbursing anything. I did not tell him about Marianne, or Renee, or Loretta. Not yet. Renata had been firm about that. You control the timeline of disclosure, she told me. Not Craig, not Todd, you. Let the facts be fully documented before anyone gets a chance to spin a story out of half of them. Todd took it reasonably well. Honestly, a little hurt, a little confused, but he'd never been a greedy man, and I think some part of him understood his father had his reasons. Craig did not take it well. Craig Marsh, 51 of Perrysburg, Ohio, showed up at my house unannounced on a Saturday in early August. I remember it was hot, the kind of sticky Ohio August where the cicadas don't stop. He stood on my porch in a polo shirt with his HVAC company logo still on it from the business that had gone under 5 years earlier. And he didn't yell. Exactly, Craig was smarter than that. He was calm in a way that felt more threatening than yelling would have. "Diane," he said, "I want you to understand something, that trust. I've talked to a lawyer. There's a strong argument for undue influence. My father was 84 on heart medication. If you think Casey's going to walk away with $2.5 million while Todd and I get nothing, you're going to find out how expensive it is to fight 2 adult sons in probate court." "Walter amended that trust in 2019, I said, keeping my voice level, keeping my hands still at my sides even though my heart was going. "He was 78. Sharp as anyone." "You're welcome to review his medical records through the estate proceeding, Craig, but I don't think you'll find what you're hoping for." "We'll see," Craig said. "I've already retained counsel. You'll be hearing from him." I did hear from him, a formal notice of intent to contest the trust, filed in Fulton County Probate Court on August 22, alleging undue influence and lack of testamentary capacity, naming both Craig Marsh and, reluctantly, a hesitant and mostly uninvolved Todd Marsh as co-petitioners. I remember standing in my kitchen holding that filing, and instead of panic, what I felt, and this surprised me, was a kind of settling calm. I had documents. I had Priya's newspaper archive research. I had a sealed divorce decree unsealed by court order. I had a living granddaughter named Renee Speck, who had no idea any of this existed and who, once she learned the truth, would either become the most important witness in this case or the most complicated wrinkle in it. I didn't know which yet. I only knew I needed to find her before Craig's lawyer did. Renata and I drove to Bowling Green on a Wednesday afternoon in September. Renee Speck worked as a vet tech at a small animal clinic off Wooster Street. We didn't ambush her. Renata insisted on a formal letter first and a follow-up call, giving Renee the choice to engage or not. She chose to meet us at a coffee shop near campus. She was thin, dark-haired, with her grandmother Loretta's jawline. I'd learned later from an old photograph, and when Renata explained who Walter Marsh had been to her, Renee went very still and very quiet for almost a full minute. "My mom used to say her father left before she could remember him," Renee finally said. "She never said his name. I always thought maybe she didn't know it herself." I told her, as gently as I could, what we'd found: the marriage, the custody arrangement, the farm, the mineral rights, the trust amendment in 2019 that had, in its quiet way, been Walter's attempt to send something back down the branch of the family he'd walked away from 50 years earlier. Renee cried, not dramatically, just quietly, into a paper coffee cup for a while. Then she asked the question I'd been dreading and hoping for in equal measure: "Does this mean I'm entitled to some of it?" "That's a real question," Renata told her honestly. "The 2019 amendment names Casey specifically. It doesn't name you. Whether a court would find that you have a claim as an omitted heir or whether we can work out something between the families directly is something we can explore. But I want to be straight with you. Nobody's obligated to include you legally. If anything gets worked out for you, it'll be because people chose to do right by you, not because a court forces it." Renee nodded slowly. "I appreciate you telling me anyway," she said. "Nobody had to." That conversation mattered more than I expected it to, because 3 weeks later, when Craig's attorney, a sharp, expensive litigator out of Columbus named Bradley Kirsch, filed a motion trying to argue that the entire trust amendment was the product of confused, isolated decision-making by an elderly man manipulated by his daughter-in-law, Renee Speck voluntarily submitted a signed affidavit describing her own family's history: the mother she'd lost to cancer, the grandfather she'd never known existed, and her belief, based on what she'd learned, that Walter Marsh had spent the last years of his life trying, quietly and without confession, to correct an old wrong. It was not, Renata told me later, technically necessary evidence, but it was human evidence, the kind that changes a room even in a legal proceeding built on documents. And it planted a seed with Craig's own case that would matter later. If there was an omitted heir, a grandchild from a first unacknowledged marriage, then the confused old man theory got a lot harder to sell because everything about the trust amendment suddenly looked less like confusion and more like a very deliberate, very sad, very human attempt to balance a lifelong scale. I should tell you, too, about the pressure that fall, because it wasn't only Craig. Bradley Kirsch requested my full financial records, Casey's medical records, trying, I believe, to paint a picture of a struggling single mother who'd have motive to manipulate a vulnerable elderly man. And for one terrifying week in October, subpoenaed records from Maumee Family Dental regarding my reliability and character as an employee. My office manager, a woman I liked named Sherry Voss, pulled me aside after the subpoena request came through the practice's front desk fax machine and asked, not unkindly, whether there's something going on I should know about for the practice's sake. I told her the truth in broad strokes, a family estate dispute, nothing that reflected on my work. And she said, "Diane, in 11 years you've called in sick 4 times. I'm not worried." That relief meant more to me than I can easily explain. I genuinely believed for a few days that Craig's legal strategy might cost me my job on top of everything else. There was another thread that fall I haven't mentioned yet because it took the longest to run down. Priya, during her archive work, had also flagged a name that kept appearing in the county recorder's marginalia next to the mineral lease renewals over the decades, a landman, someone who brokers mineral rights deals named Herschel Dunmore, who'd apparently handled the original 2009 lease negotiation on Walter's behalf and had, according to a set of old phone records Renata subpoenaed from the estate's financial records, spoken with Walter by phone 11 times in the 6 weeks before the 2019 trust amendment was signed. I remember sitting in Renata's office going through a printed call log, dates and durations in a plain courier font, feeling like I was watching the shape of a decision get made one phone call at a time, 30 years after it should have been made, and 5 years before Walter would run out of time entirely. Renata tracked Herschel Dunmore down. He was 81 himself by then, living in a retirement community outside Toledo, and he agreed to a recorded phone interview. He remembered Walter well. "Sharpest man I dealt with in that whole basin," he told us. He asked me more than once whether there was a clean way to send money to a grandchild he'd never met without it turning into a family war. I told him there wasn't. Not really. Guess he found one anyway. That interview became part of the evidentiary record too. Not a smoking gun exactly, but one more brick in the wall of a story that kept confirming itself from every direction we pushed on it. I also want to tell you about a smaller moment that fall, because it stayed with me. In October, on one of the worst weeks, the week of the Maumee Family Dental subpoena, the week Casey's blood sugar had spiked badly enough that we'd spent 4 hours in an urgent care waiting room, I almost called Renata and told her to make it all go away, offer Craig a settlement, split the trust 3 ways, just end the fighting so I could go back to an ordinary life where nobody was reading my employment file in a courtroom. I actually had my phone in my hand, her number pulled up, when Casey came and sat next to me on the couch, still in her hospital bracelet from that afternoon, and asked what was wrong. I told her, honestly, that I was tired of fighting for money that wasn't really about money anymore. She thought about it for a minute, and then she said, "Mom, I don't care about the money, but I want to know why Grandpa Walter did what he did. Don't you want to know?" I put the phone down. I did want to know. That was the night I stopped thinking about settling and started thinking about finishing what we'd started. By November, Renata had assembled what she called the whole architecture: the 1968 marriage record, the 1969 birth certificate, the sealed 1971 divorce decree with its custody for farmland arrangement, county tax records showing Walter had quietly paid the mineral rights taxes on that land every single year for 42 years, even after selling the surface, a 2019 trust amendment executed with a notarized capacity affidavit from Walter's own treating physician, Dr. Aaron Pell, confirming Walter was lucid and competent at the time of signing, and Renee Speck's voluntary affidavit. Craig's motion for undue influence, Renata told me over the phone one evening in late November, her voice carrying the particular satisfaction of a woman who'd built something sturdy, "doesn't have a leg to stand on anymore. It has maybe half a leg." We're going to the hearing, and we're going to end this. The hearing was set for December 9th in Fulton County Probate Court before Judge Marian Alvers, a stern woman in her 60s who I'd later learn had presided over 3 decades of exactly this kind of family estate dispute and had very little patience for theatrics. I wore a plain navy blazer. I remember that detail because Renata had told me the night before, dress like someone who doesn't need this money, even though you do. Calm reads as credible in that courtroom. Craig is going to come in, hot, let him. She was right. Craig came in with Bradley Kirsch at his side, and from the first minute, his energy filled the room in a way that didn't help him. He kept leaning over to whisper to his attorney. He shook his head visibly when Renata spoke. Todd sat a row behind Craig, quiet, hands folded, looking like a man who wished he'd never agreed to be a co-petitioner in the first place. Bradley Kirsch opened with the undue influence argument, painting me, gently but clearly, as a woman who'd inserted herself into an elderly, medicated man's decision-making. Renata let him finish. She didn't interrupt once. Then, when it was her turn, she stood, walked to the evidence table, and laid out the architecture piece by piece, calm and unhurried, the way you'd lay out a hand of cards you already knew was a winning one. "Your Honor," she said, "Mr. Kirsch describes Walter Marsh as confused and manipulated. I'd like to walk the court through 42 consecutive years of mineral rights tax payments. Mr. Marsh made privately without disclosure to either of his sons, on land tied to a marriage and a daughter neither of his sons knew existed until this proceeding." She placed the tax records down. "I'd like to introduce a sworn capacity affidavit from Dr. Aaron Pell, Mr. Marsh's treating physician of 11 years, executed the same week as the 2019 trust amendment, confirming full lucidity and understanding." She placed that down too. "And I'd like the court to hear, briefly, from Renee Speck, granddaughter of Walter Marsh, through his first marriage to Loretta Speck in 1968, a woman these petitioners did not know existed until my research team found the records they did not want found." I watched Craig's face while Renata spoke. I want to describe this carefully because it's the moment I remember most clearly from that whole year. Craig had been leaning forward the entire hearing, jaw tight, one knee bouncing under the table in a steady, agitated rhythm. When Renata said the words "granddaughter of Walter Marsh through his first marriage," the knee stopped, just stopped, mid-bounce, like someone had cut a wire. He went very still and very pale, and he didn't look at me, or at Renata, or at the judge. He looked down at the table in front of him, at his own hands, for a long moment. Bradley Kirsch, beside him, went equally quiet, the tell of a lawyer who has just realized in real time that his client left something important out of the story he'd been told to work with. Judge Alvers asked Craig directly at one point whether he had known of Walter's first marriage prior to these proceedings. Craig said quietly, "No, Your Honor, I did not." It was the only thing he said in the entire hearing above a murmur. Renee spoke for maybe 4 minutes. She wasn't dramatic. She talked about her mother, about growing up without knowing her grandfather's name, about learning, this fall, that he'd spent decades quietly paying taxes on land tied to the daughter he'd given up custody of in exchange for peace. When she finished, the courtroom was very quiet. Bradley Kirsch tried, in his closing, to salvage the undue influence argument, but even his tone had changed. Less certainty, more procedure. Judge Alvers took a 15-minute recess and came back with a ruling from the bench. The trust amendment stood as executed. Walter Marsh's testamentary capacity was not in question. The petition to contest was denied in full. Craig didn't say anything as we left the courtroom. He just gathered his coat, and I saw his hand shake slightly as he buttoned it. Small, involuntary, the kind of tremor you get when adrenaline has nowhere left to go. Todd caught up with me in the hallway outside, alone, and said quietly, "I didn't know any of that, about Dad. I'm sorry I let Craig talk me into this. I believed him. I still do. The resolution, the court's ruling, meant the 2019 trust amendment stood exactly as Walter had written it. Casey Marsh, sole beneficiary of the Fulton Ridge Holdings Mineral Rights Royalty Trust, with me as trustee until she turned 25, total value at the time of the ruling standing at $2,411,000 plus, continued monthly royalty income of roughly $18,000, which would keep accruing to the trust until Casey came of age to manage it herself, at which point she'd also inherit full discretion over the underlying mineral rights themselves. Craig and Todd received nothing from the Mineral Rights Trust, as Walter had specified, though separately, through Walter's regular estate, his modest retirement accounts and the sale of his condo in Sylvania. Todd and Craig split roughly $140,000 as originally provided for in Walter's unrelated will. Craig's legal contest cost him, by Renata's later estimate, close to $30,000 in attorney's fees, money he did not have to spare, and I heard through Todd, months later, that it strained things badly between Craig and his own wife. Renee Speck received nothing from a court order, the amendment didn't name her, and Renata had been honest about that from the start. But Casey, once she turned 18 that January and I explained the full story to her, made a decision entirely on her own, without any pressure from me. She asked Renata to help her set up a smaller, separate gift trust funded with $150,000, naming Renee Speck as beneficiary, because Grandpa Walter meant for it to go back to that side of the family. Casey told me he just ran out of time to do it directly. I cried when she said that. I'm not embarrassed to tell you that. I resigned from Mommy Family Dental in February, not because I had to, but because it was time. Sherry Voss cried a little when I told her, and made me promise to still come in for my own cleanings. I paid off Casey's remaining medical debt in full, switched her onto a private, more comprehensive insurance plan that fully covered her new insulin pump and CGM, and put a down payment on a modest 3-bedroom house 11 minutes from where we'd been renting, close enough that Casey didn't have to change schools for her senior year. The epilogue. It's been a little over 2 years now since that cream-colored envelope showed up in my mailbox. Casey is 19. A sophomore at Bowling Green State University studying veterinary science. She and Renee Speck, it turns out, get along well. Renee occasionally lets Casey shadow her at the animal clinic, and there's something quietly right about that, 2 branches of Walter Marsh's family finding each other on their own terms, without lawyers in the room. Casey still texts me pictures of dogs she's helped treat, with captions like, "This one has your bad attitude in the mornings," which I choose to take as a compliment. Priya Nair, the research assistant who spent 4 days squinting at microfilm and found the marriage announcement that cracked this whole thing open, finished her paralegal certification that spring and now works full-time for Renata's firm. Renata told me, with what I can only describe as reluctant pride, that Priya has an unhealthy love of dead-end archives, which in this business is the highest compliment I know how to give someone. Sherry Voss retired from Maumee Family Dental last year after 26 years there. I drove out for her retirement party and brought a cake, and we stood in the parking lot afterward talking for almost an hour about nothing in particular. The way you do with people who knew you before anything changed. Dr. Aaron Pell, Walter's old physician, passed away himself about a year after the hearing, heart trouble, the same as Walter, which felt like a strange, quiet echo when Todd told me. Herschel Dunmore, the retired landman, sent Casey a card the following spring. Unprompted, just a short note saying he was glad Walter's business finally got settled the way he wanted it. Casey keeps it in the same drawer where she keeps Walter's old birthday cards, the ones with the $20 bills folded inside. Todd and I are, if anything, on better terms now than we were before all this started. He still works fleet logistics in Perrysburg. He remarried last year, a woman named Beth, who I actually like quite a bit, and he walks Casey to her car after visits the way he always has, out of old habit. Craig and I don't speak. Todd tells me Craig eventually closed on a smaller HVAC repair job with another company and seems to be doing okay, financially if quieter than he used to be. I don't wish him ill. I think, honestly, he was just a man who'd never learned what to do with the parts of his family history that didn't make him look good, and he reached for the version of the story that hurt the least. Renata Ochoa still calls me every few months, mostly just to check in. though I suspect also because she likes knowing how a case she cared about turned out. She keeps a photo. She once told me of every client whose case she genuinely believed in tucked in the back of a desk drawer. I asked if I made the drawer. She said, "You made the drawer, Diane." Renee still runs into Casey at the clinic, and last Thanksgiving, we actually had them both over, along with Todd and Beth, an odd little gathering of people connected by a man none of us fully understood until after he was gone. I set the mineral rights deed matted and framed in a hallway closet, not displayed anywhere because I never wanted this house to be about money. I wanted it to be about what the money uncovered, which was a truth Walter Marsh spent 50 years too afraid to say out loud, and which cost him nothing at the end to finally, quietly put right on paper. If there's one thing I've taken from all of it, it's this. The people who love us don't always know how to say the hardest things while they're still alive to say them. Sometimes they leave the truth behind in paperwork instead, in deeds and trusts and tax filings, hoping someone patient enough will go looking. I went looking. I'm glad I did. If you're out there right now sitting on some paperwork you've never fully understood, an old deed, a strange account, a relative's unexplained silence about something, don't be afraid of what you might find. The truth, even the complicated kind, is almost always kinder than the not knowing. So tell me, if you found out tomorrow that a relative had kept a secret like this for 50 years, would you have gone looking the way I did, or would you have let it stay buried? Let me know in the comments below, and if you like this story, don't forget to subscribe for more.